Good afternoon, law nerds. Happy Thursday. It's January 25th. We have a lot to do today. So, replay crew, love you, replay crew. Everything will be timestamped down below. We need to talk about what's happening in court today and tomorrow. We need to talk about what's happening in the TikTok psychic case. So, we're going to cover TikTok psychic stuff while we wait for court to start in New Mexico. The Law Nerds mentioned this in the members only stream yesterday, and I was like, oh, I wonder if there's anything interesting going on in the Hannah Gutierrez Reed case, or if it's just like a regular pretrial conference before this goes to trial next month. Because if it's just like a pretrial conference, it's like, okay, is everybody ready for trial? But the defense has made a motion to dismiss. Y'all. It seems that the prosecution turned over a bunch of defense and defense attorney communications to a key witness. And that is some scorching hot tea that I cannot turn away from. I have so many questions. We're going to see what happens. Because this motion to dismiss is going to be fire. If they can't call this witness, I don't know how they prosecute this case. You know what witness they turned it over to? You know what witness? Hannah Gutierrez Reed is the armorer in Rust. They turned over communications between her and her attorney to their key witness, the person who owned the prop house, Seth Kinney. How in the world did that happen? Why did they even have them? Like, what is happening? So we're going to watch that hearing in court today because I don't even know what that's like. Why do the prosecutors have those in the first place? And then how do they get accidentally turned over to the person who has the prop house, who's never been prosecuted in this case, who is the one who brought the bullets onto set before a bullet ended up in a gun killing Helena Hutchins? It's what? So we're going to go to court in New Mexico today and try to figure out WTF is happening and why, because this shit is bananas, BANANAS. But before we do that, we have had some heavy topics this week. Everyone needs a giggle. So we're gonna go to Idaho and see the new motions in the TikTok psychic defamation case in federal court. The TikTok psychic is representing themselves, and there is now a motion for punitive damages. So they have more information to add punitive damages, the punishment ones, the you did a bad thing damages. And they are also amending their motion for summary judgment because apparently the TikToker responded to all those interrogatories and requests for admissions that they had not previously responded to. But buckle up. Today's going to be spicy. Let me know where you're coming in from, what you're drinking. I've got a lukewarm coffee that I'm going to finish, but today's going to be spicy. Law nerds, let's ride. Oh, and then I'll tell you what's going on the rest of the week. But let's ride first.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
You're hydrated. Y'all are coming in from all over the world. Y'all are a good hydrated bunch. I love to see it. I love to see where you're coming in from, what you're drinking. It's so fun to see like the Dr. Pepper fans and the Pepsi fans not fighting in the chat. I know, it's great. Everybody coming in like, I'm drinking water. And then the undisclosed, I'm coming in from work. Shh. It's fine. Your secret is safe from me. Kelly, this is so on the nose. I love it. Tea from London. You know, the weather in London and the weather in Middle Tennessee is probably not all that different right now. Gray and rainy. It's warmer here. So with all of it, we're going to rocking some coconut water coming in from Mexico. Miss K, we're going to New Mexico today, not Mexico. The international stuff is hard because I don't know much about international law, but I love our international law nerds, and I see so many of you in the chat. let's talk about oh, you Brits, I love you so much. I love you so much. I love you so much. Let's talk about what's going on the rest of the week. You may have heard a thing or two about Murdaugh. There is a brief Murdaugh hearing tomorrow. To road so far, those of you who are not following Murdaugh, the evidentiary hearing starts on Monday. I will be here, gavel to gavel. We are riding. The way we will ride for Murdaugh starting on Monday. One of the jurors had a conflict and could not testify in the evidentiary hearing next week. So they are testifying on Friday. And you know what Justice Toll did? Justice Toll was like, it's just one juror, no cameras, no recording, no audio, no video, no fucking nothing. Paraphrase, that's not actually what Justice Toll said. So I'm real salty about the court's updated media order that said nothing will be happening tomorrow. So there is nothing to cover. We will have to wait for those that are in court in South Carolina tomorrow to tweet out what happens, because we're not going to get any updates. There's no media in the courtroom. Well, there's no cameras in the courtroom. Media will be present. We'll have to wait for them to share. So just one juror is testifying tomorrow because of a conflict next week. So I'm annoyed that there's no filming, but it's one of Eric Bland's jurors, so I don't doubt that we'll hear exactly what happened from Eric Bland himself at some point. So who knows? So yes, that hearing's going on tomorrow. No, I can't stream it because there's nothing to stream, but we will talk about it after it happens. So that's an early morning hearing tomorrow, but we have a hearing in Idaho tomorrow afternoon. Idaho has 2 hearings tomorrow. One of them is sealed to the public in the morning, and one of them is public in the afternoon. We are going to go to court in the afternoon in Idaho and cover the public part of the hearing. The court is streaming it. This is the first time an Idaho hearing in this case has been streamed. The court has been putting them or allowing them to be filmed and released on delay. We don't have to wait for delay. We're going to stream it directly from the court's website, and we're going to see what happens in that hearing tomorrow with regard to appeals at all. So we're going to be in court tomorrow afternoon. This is my time to remind you, if you have not downloaded the free Law Nerd app, it is a free Law Nerd app. If courts shift, if things change, if anything happens, we will let you know in the app first. So lawnerdapp.com is where you want to be. Lawnerdapp.com is where you want to be. That will keep you in the loop. iOS, Android will get your notifications. Hit the link. It's pinned in the description. It will keep you in the loop, because next week, my goal for those of you, particularly those of you that are like, Emily, I have to leave my house Monday, Tuesday, and Wednesday at some point, to which I say, I'm so sorry. But what I plan to do with the app is to let you know when we switch over witnesses, when there's a lunch break, when we're back from a lunch break, so that we can keep you in the loop. So if you need to take a pause, like, oh, the court's at lunch, the app will let me know when we're back from lunch. Exactly. The secret to all my love is being in the app. Octo. So I'm going to keep you in the loop on everything. And remember, at the beginning of the Depp Heard trial, for those of you in the text crew, I was able to send out texts when we switched over witnesses and stuff. And we're going to do that. We're going to send out app notifications when Courthouse Becky testifies, when the jurors switch over, when there's a court break, so you know that you've got a minute to get back, all of it. How's Griffin? Sick. Griffin, my little man, is not feeling well. So we're going to do all of that in the app. So Friday, I'm streaming. We're streaming a lot this week. Friday, we're streaming, and then we're streaming Monday, Tuesday, Wednesday. And then if we need more days for Murdaugh, we'll take more days. One of these days, we're going to go over the new Courthouse Becky emails, because at the end of the email dump, Courthouse Becky's talking about how annoyed she is that Dick and Jim are making all this fuss over her. But here's what I want to do, because sometimes I'm shady. It happens. I want to wait until after her testimony and then go over some of those emails and see how they age. Does that mean? I'm just curious. I just want to see how they age. They're either going to age well or they're going to age like milk. They might age like Gen Z. I don't know. We're going to see what happens. I'm going to wait and see what happens. So that's what's happening at the beginning of the week. We've got a ton of other cases that are active that we need to catch up on. We'll be doing some of that in the podcast and some of that later in the week, but we're hitting the ground running. So yes, let's start with TikTok, shall we? Do we do the motion here? Let me see. I'm gonna put a poll up. Well, I should have done this before. Where do we start? Do we start with the motion for summary judgment or the motion for you done fucked up damages? You did a bad thing, damages. So you guys let me know. Do we start with a motion for summary judgment or the motion for punitive damages? Both of those are in the Idaho TikTok defamation case. Let me swoop and then we'll go from there. I know that, look, there are only so many cases where we can be shady because some of the stuff we handle is so deeply serious. There's no room for sass. But today there's lots of room for sass and I feel alive. So let's go to Idaho real quick and then give a road so far, shall we? Okay, before we do a road so far, this caught my eye and I had to do this. Yule said, "Can I get a shout out for my hubby, Jonas? It's his birthday and he's here eavesdropping. My name is Jonas." Does anyone else hear Weezer immediately with the name Jonas? Jonas, happy birthday. We are singing My Name is Jonas to you. Anyway, I love Weezer. And it's rare we sing anything other than the sweater song. So my name is Jonas. Happy birthday. And thank you for giving me the opportunity for these songs to sing in my head. Let's see what the law nerds have decided. Oh, it's so close. 55% motion for summary judgment, 45% motion for punitive damages. Y'all want to save the money shit till last. I respect you for it. What? Emily, you need to prep your streams better. This says 124 pages. Girl, what? Damn it. We're professionals here. Why is this motion 124 pages long? What is... We have court at 2. What is happening? 124 pages. Oh my God. I just saw that the motions were there and I was like, this is amazing. And I didn't think much more about it. Fail. I failed you. No, we're going to speed read. It'll be fine. We're going to do it. Let's see what's filed here. This amended motion for partial summary judgment is supported. Oh, I didn't road so far. Damn it. Here's the road so far. I got distracted by the girth of this motion. TikTok defamation case. Here's the short summary. University of Idaho professor Schofield was accused of hiring this murderer as a hit because of a relationship with one of the victims. The TikTok psychic was sharing her gifts on TikTok, saying that this professor was essentially a murderer, that she had hired the murderer, that she had a relationship with a student, which if you are a professor is inappropriate and violates all of the codes of the university and more, and all the rest of it. The professor sent multiple cease and desists, and TikToker, being a content creator, promptly mocked those cease and desists, did not follow them, and found themselves in a federal lawsuit. The TikToker is representing themselves in federal court, and in doing that has missed some arguments that could have been made, has made some other arguments that shouldn't have been made, and has shown us that federal judges can be the most patient humans on earth when they are dealing with attorneys who are not attorneys, when they are dealing with defendants representing themselves. This judge has been incredibly patient. This defendant has gotten so many chances, like more chances than any attorney would have gotten, has gotten an incredible amount of chances, and still goes on the internet and says that the judge is biased against them, which is the furthest thing I have seen from the truth. If I was the plaintiff's attorney at this point, I would be like, Your Honor, at this point, like, you're prejudicing our case by not holding the other side to the rules. That's where I would be on this case. But the judge has been incredibly patient. The TikToker did not respond to requests for admissions and interrogatories. and was required to. The plaintiff, professor, filed a motion for summary judgment to resolve this case on the matter of liability for defamation. So if this motion is granted, it means the court will find as a matter of law the defamation happened, and it will go to trial with basically how much money are you going to get for damages only, not liability. The court gave the TikToker additional time to answer and was like, no, you actually have to take this seriously and answer these questions. So if the TikToker answered, the court allowed the plaintiff to file an amended motion for summary judgment, and that's what we're looking at today. I really hope these exhibits include emails, because every time we get emails in this case, it's spicy. So plaintiff, professor, moves the court for partial summary judgment as to liability on each of her claims. The amended motion is supported by memorandum in support, an amended statement of undisputed material facts, an amended declaration of the attorney with exhibits, and an amended declaration of Professor Schofield with exhibits. So lots of exhibits in this motion for summary judgment. When I was working as a civil research attorney for judges, sometimes our motions for summary judgment would show up in like a box of exhibits, and I would be like, oh my God, that's a box of exhibits. So in fact, 124 pages is not bad. I should have planned, but I did not. I was galloping into ridiculousness with the members on a members only live last night instead. That's what I was doing. Let's see. Ms. Gouliard's responses to requests for admission do not raise a genuine dispute of material facts. They support an award of summary judgment. The facts conclusively establish TikToker's admissions, the TikToks she posted, and professor's declaration demonstrate the professor is entitled to judgment as a matter of law. If the professor gets judgment as a matter of law, the professor would only go to trial on damages. Kind of like the Alex Jones case. Alex Jones wouldn't participate, and the court's like, you've defamed. Go to trial on the damages only. That's what they are trying to do here. Introduction. Plaintiff, professor, respectfully requests the court enter summary judgment on both her claims. Let's see. Both her claims, because as a matter of law, TikToker has admitted to defaming the professor. And if there's no material issue of fact, there's nothing for a jury to decide. Jurors decide the facts. This party says this happened. This party said that happened. Where is the facts? If there's no facts to determine, then as a matter of law, donezo, right? Gouliard's admissions, the TikTok videos she posted online, and the professor's declaration established beyond dispute that TikToker is liable for her defamation of the professor. Accordingly, all that remains is the jury to determine damages. And even when the jury determines damages, do we think that this jury, whatever they award, do we think this professor is going to see a dime from this TikToker? Background. We know the background. We know the history of this. According to TikToker, she used her spiritual practice, psychic abilities, and metaphysical tools, including tarot cards, to post over 100 TikTok videos of her supposed quote unquote findings concerning the murders near the university. TikToker's purported findings, which she posted on social media, TikTok, went like this. No, please tell me. Professor Schofield had a same-sex affair with one of the victims and then, quote, planned, initiated, ordered, and executed the murder of the 4 University of Idaho students. TikToker has admitted that she made those statements, although she now claims she was just relying on the results of a tarot card reading, and she has admitted that those statements were not based on any facts. Okay. TikToker has admitted that her false statements are based on her quote-unquote spiritual research, intuition, and instincts, and that she currently has no written information or oral information from another human being to support her false statements. She has no knowledge outside of her tarot card reading. Look, I have absolutely no beef with tarot cards, with spirit, with intuition, with psychic mediums, with any of it. I grew up in California. I can be woo to the power of woo to the third woo-woo. But what you can't do with the woo-woo is accuse people of murder, because it's defamatory per se. And you have no reason to believe that these are based in fact. You can't. Okay. What you can't do. Chat, you mean the woo-woo doesn't hold up in court? What's not going to hold up in court is, but Your Honor, it's what I saw in the tarot cards. It's what my intuition believes. I believe it in my brain. And because I believe it in my brain, it's true. Look, I go to therapy to try to prove to myself that some of the things I believe in my brain are actually not in fact true. But the TikToker has maintained that she is a spiritual witness to these cases. All the happy squirrel said, wait, did TikToker admit she had no factual basis for her assertions? Did I hear that right? Yes, you continue to hear that right. Because the TikToker has maintained that all of this is religious persecution and that her spiritual research, intuition, and instincts are sufficient fact for her to be making statements of fact, not to be making statements that are defamatory. But again, not how that works. Not how that works. Ron Ralph said, I don't think you can call a spiritual witness to the stand, correct? So does that mean it's over? I don't know how it goes forward. I want to see the tarot cards cross-examined. Just bring them up. What card did you pull? Your Honor, I call the tower to the stand. What is happening? And again, I use the tarot cards in your own personal practice in your life for the people who hire you for readings. Do you? But you can't go on the internet based on things that you have decided and accuse someone of a heinous murder or other crimes. More like the Hanged Man. Chat, Gothboy UK. The wit is so quick always, and I appreciate you. Objection, metaphysical hearsay. I love you so much, chat. Gouliard has admitted that her false statements are based on spiritual research, intuition, and instincts. She has admitted that this is all that she has. Therefore, there is no substantial issue of fact. Therefore, the court needs to determine liability. That's it. She has no written information or oral information from another human being to support her false statements. She states that she hopes to find facts to support her position through discovery in this case, but so far she has none, even though discovery is closed. That paragraph is the end of this case. And I have no reason to believe these attorneys are not representing things accurately. I have seen nothing but integrity from these attorneys and patients. She states she hopes to find facts to support her position. Here is the thing. You need to have those facts at the time you make the statement, or it's still fucking not hearsay, defamation. Like, you have to have the facts at the time you're making it. You can't just find facts later. Can we please see Wendy Olson in her full-on cross-examination mode for like 4 hours? God, I hope so. In a good faith attempt to resolve this matter without litigation and to avoid drawing further attention to TikTokers' utterly baseless statements, Professor sent cease and desist letters. TikToker promptly discarded them and chose to continue spreading false information for her own pecuniary gain. We know the procedural history of this case goes something like this. TikToker is not a lawyer, does something non-lawyerly, and the court goes, ma'am, I need you to do this. And then she does it, and the court gives her another chance. Let's see. Professor Schofield served TikToker with discovery requests, including requests for admissions, interrogatories, and production, pursuant to Rule 36 on June 20th, 2023. TikToker's response to those requests were due no later than July 20th. TikToker did not respond to those discovery requests, including requests for admission by July 20th. Professor then filed the motion for partial summary judgment October 6th. Based on TikToker having, as a matter of law, admitted to all the required elements of defamation per se through her failure to respond to the request for admission. TikToker did not respond to any of those discovery requests until December 15th. December 15th. Yes. Emily, 120 pages will speed read. Actually, Emily barely gets through the first paragraph. Correct. TikToker does not respond to any of those discovery requests until December 15th, after the court sua sponte, of their own volition, allowed her to do so during a December 7th status conference. They are reminding both the TikToker and the court that the court has allowed a tremendous amount of space and grace for this TikToker. An attorney fails to respond to these things in a timely fashion, the case is toast, and that attorney gets sued for malpractice. The court also allowed Professor to file an amended motion for summary judgment after the late served answers. Although TikToker served responses to the professor's request for admissions on December 15th, she did not ever respond to the interrogatories or requests for production. So she still hasn't participated in discovery. You can find someone liable as a discovery sanction. We've seen it in other cases. Professor sent a deficiency letter December 20th requesting responses by the 29th. TikToker sent an email January 1st stating she was on vacation. When the deficiency letter was sent, she would get back to the professor by the end of week and has not responded. Guess what lawyers don't do? Go on vacation. Miss deadlines because they're on vacation. We've gone through the legal standard in this a couple times. For summary judgment, there must be no dispute, essentially, of fact. We're not going to go through the legal standard again. We've gone through it. I want to get to the exhibitees and the admissions, because if she admitted to all of it, we're done. Ms. Gouillard's responses to requests for admission do not raise a genuine dispute as a matter of fact. They support an award of summary judgment. TikToker's untimely responses, they're not going to let that go. I wouldn't. TikToker's untimely responses to the request for admissions further established that TikToker published defamatory statements about the professor and that TikToker has no facts or admissible evidence showing that the professor was involved in the murders or that the professor had an affair with one of the murdered students. Through her request for admissions, the professor sought admissions regarding, first, TikToker making public statements that the professor was involved with the murders of the 4 students and that she had an affair with one of the students. 2, the falsity of those statements. 3, the basis for TikToker's statements was her spiritual research, intuition, and instincts, that she was not aware of any physical evidence or written information linking the professor to the murders or to having an affair with one of the victims. Through her responses, hold on. Tell me what she said in her admissions, because there's no walking these back. Once you've made these admissions, you are stuck with what you've admitted. Through her responses to the request for admissions, TikToker claims that she was just announcing the results of a tarot card reading when she made her TikToks and posted them on the internet, stating that the professor was involved with the murders and that the professor had an affair with one of the students. But she admits posting them. You're not reading the results of like a poll or a newspaper article. Like, what? She also admitted she continued to state publicly that the professor was involved with the murders and had an affair, even after she received the cease and desist, and after she knew that Moscow police had issued a press release stating that the professor was not involved in the murders. The police department issued a press release stating the professor was not involved. That's how much attention these TikToks got online. That the police department, in the middle of a murder investigation, had to address this sideshow. She also admits she never received any information communicated to her orally that the professor ever met the victims. No, she received it as intuition. In responses for requests to admissions asking her to admit that she had no written information or physical evidence showing the professor ever met the murdered students, TikToker stated that she could not admit or deny because discovery is still pending public information from the victims. Social media may show plaintiff met the murdered students. That's not going to get you there. You have to know it before you say it. Not, well, it could have been. It could have been is not enough. Lori in CT said, I hope the professor recoups her attorney's fees. I hope so too, but unlikely. RK said, not how discovery works. Exactly. Can you receive some cash through intuition? Good luck. Good luck, Steve. Manifest that shit. TikToker responded similarly that when asked to admit she knew of no physical evidence linking the professor to the murders and that she was not aware of any physical evidence showing the professor had an affair with the victim. She stated, quote, I deny this matter. There's plenty of evidence to be discovered during the civil discovery process or criminal trial. So she's dodging. In response to requests for admissions asking TikToker to admit that she never communicated with JD or Brian Koberger, she responded, I cannot admit or deny this matter. Many people have anonymously contacted me by way of electronic communication. Well, that's a very clever answer, isn't it? She's like, could have been. I don't know if Brian Koberger contacted me. A lot of people DM me. I mean, a lot of people DM me too. Do I know all of their real names? No. It is a calculated and clever answer. So for all of you that ask if the TikToker is competent to stand trial in this, she knows exactly what she's doing. In response to requests for admission asking TikToker if she ever communicated, okay, we did that. I can't admit or deny. A lot of people say things to me. In response to requests for admissions asking TikToker to admit her statements were false, TikToker denied the request for admission, stating that the professor has not proven that she did not have an affair with one of the victims and that she was not involved with the murders. Oh, ma'am. Cleopatra 597. Rust hearing is up next. We haven't gotten there yet, so you're not even late. Her response to you defame someone is they didn't prove it's not true. That's not what you have to do. They didn't prove it's not true. So it could be. It's in the realm of it might could. And if it might could, then it's not defamatory. No. This isn't on the professor to prove that she didn't or that she didn't. This is on you to prove that you knew for a certainty that what you were saying was true when you said it. Finally, TikToker admitted that she did not have any written information showing the professor ever met the victim, ever met the student that TikToker said the professor hired to commit the murders. She stated, quote, as of today, December 15th, this matter is admitted. However, discovery is still pending. That's not how that works. In short, TikToker has admitted that she has no affirmative facts to indicate in any way that the professor had an affair with one of the victims or was involved in the murder, nor will she develop any. The discovery deadline was December 15th, the same date that Gouliard served her responses. Thus, fact discovery is closed. The effect of an admission under Rule 36 is clear. A matter admitted under this rule is conclusively established. Taken together, Gouliard's December 15th responses to the request for admissions establish as follows. Ms. Gouliard stated publicly that the professor was involved with the murders of the 4 University of Idaho students. Gouliard publicly stated the professor had an affair with one of the victims. Gouliard continued to make such public statements after receiving a cease and desist from the professor and after becoming aware that the Moscow police had issued a press statement stating they do not believe the professor involved. TikToker has no evidence or facts showing the professor was involved with the murders, or no evidence or facts showing that the professor had an affair with one of the victims. There's nothing else left to prove. The facts conclusively establish that TikToker's admission, the TikToks that she posted, and the professor's declaration demonstrate the professor is entitled to judgment as a matter of law. In a defamation action, a plaintiff must prove that the defendant communicated information concerning the plaintiff to others, that the information was defamatory, and that the plaintiff was damaged. Remember, this is a defamation per se case, so damages don't even have to be conclusively proven. Because defamation per se, the subject of which the per se thing is, in this case committing crimes, is presumed to be so reputationally damaging that you don't have to prove how it was reputationally, how it damaged you, how it monetarily damaged you. And the professor wasn't a public figure, so we don't even have to show all the public figure standards. This is a lower bar defamation case, which is why the TikToker is going to lose spectacularly. Essential Adventurer said, "Can you imagine someone doing this to you? Yikes." It's what's so frustrating about cases where people seem to be judgment proof, where the TikToker is like, I'm representing myself. I don't have a house for you to take. I don't have anything for you to take. You're not going to get any money for you. What do you do? Like, what do you do? CB, the professor is not a public figure as to this. No. If they were talking about university policy and the professor sat on that board, the professor might be a limited public figure as to something the history department at the university was doing, but isn't a public figure as to this homicide. No. Mm-mm. And no one's arguing that she is. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting a person's business. When people Google this professor's name for the entirety of the future, this will come up. And since this initially happened, no one, aside from me and maybe a few other commentary channels here on YouTube, are covering this. The media is not still covering this case. Ever. So the hard thing with these cases, and one of the things I feel very strongly about, is that the media covers the headline of the initial lawsuit often and then doesn't ever circle back. And even when they do, it can be 3 or 4 years later where the public awareness has moved on. So even if you see a story like Professor Cleared, you're like, what professor? What? I don't know. The damage is done, the coverage is done, and everyone's moved on. The amount of people that this video and others will reach talking about the professor's arguments and their fight to clear their name and reputation is going to reach a fraction of the people that these initial TikToks and the initial reports on this reached. It's absolutely abhorrent. Nick, good to see you. Nick said, I believe in psychics, but I don't believe in this one. Most people who share their gifts online have ethics. So this is not ethical at all. This behavior is abhorrent, and it's so hard. Just Jen, good to see you. You emphasized this point with the Michael Orr case. Yep. And we're going to be getting back to that case in a week or two. But it's such a problem, and it's so hard to clear your name. It's why I look at people who are like, did you hear about this situation? It's part of the why, Emily, you've got to move through this quickly, and you're not at all. When people are like, did you hear about this situation? My general response to everything is I need more information. And it's because of stuff like this. I reserve judgment, sometimes too long, but I reserve judgment. I want more information about literally everything. Defamation per se is per se if it ascribes to another conduct, characteristics, or a condition that would adversely affect their fitness for proper conduct or lawful business, trade, or profession, imputes serious sexual misconduct to another, imputes to the plaintiff a criminal offense, a loathsome disease. Remember, this came up in the Cardi B case when Tasha K was sued for defamation. The loathsome diseases came up in there because I believe it was a contagious disease is the language in in Georgia, but accusing someone of having a loathsome disease or committing a criminal offense can be defamation per se, or a matter incompatible with his trade, business, profession, or office, or serious sexual misconduct. Those are all the per se. Professor Schofield is entitled to judgment as a matter of law on count 1, and then it goes through again establishing count 1, and this is going to go through count 2 as well. Gouliard's communications were defamatory per se. Agreed. Gouliard's statements unambiguously impute the professor's conduct constituting a criminal offense that would be punishable by imprisonment in the state or federal institution. They accused her of conspiracy to commit murder and murder. They basically accused her of what Donna Adelson's being prosecuted for. Indeed, Gouliard admitted that she stated publicly that Schofield was involved with the murders. Gouliard's admissions and the uncontroverted evidence in this case conclusively establish that TikToker's statements impute the professor conduct constituting a criminal offense. Yeah, accusing someone of murder is, lawyers have to go the long way round, but accusing someone of murder is defamation per se. And lawyers can't just say, but Your Honor, like, obviously. Your Honor, it's obvi. Professor Schofield's entitled to judgment as count 2 as a matter of law, and this goes through it being per se imputing a professor an improper sexual relationship with a student based on the professor-student relationship. Professor-student romantic relationships are improper, and that would impute their reputation. Gouliard's statements ascribe conduct to a professor that is incompatible with proper conduct of a professor. And that would be a romantic relationship with a student. No facts support any defense that Gouliard's statements were true. Truth is a defense to a defamation claim that ordinarily must be proved by the defendant. TikToker. On summary judgment, where the non-moving party bears the burden of proof at trial, the moving party need only prove that there is an absence of evidence to support the non-moving party's case. There is an absence of evidence that any of this was true. No facts support Gouliard's statement that the professor had any role in the murders of 4 students. Conclusion. For the reasons stated herein, the professor respectfully requests the court grant the motion for summary judgment. Let's see what we've got by way of exhibits. This is plaintiff's amended statement of undisputed material facts. That's all in the motion. We went through all of those undisputed facts. These are all coming from Gouliard's responses. Let's see. Declaration of the attorney attaches Exhibit A, a true and correct copy of Gouliard's responses to the first set of interrogatories. Yes, please. Exhibit B, cease and desist letter. C, cease and desist letter. Press release from Moscow. TikTok published, and then all of these are TikTok files that are going to be lodged with the court. So all of those are TikTok downloads. Plaintiff's first set of interrogatories served on plaintiff by email. Letter I wrote and cover email. So those are the emails. So that's why it's so long. Request for admissions. Admit that you have stated publicly that Rebecca Schofield had an affair with one of the victims. Response. I admit in part and deny in part to this matter. Specifically, I admit I stated publicly the results of a tarot reading. The tarot reading revealed that the professor had an affair. Admitted. Admit that you have stated publicly that professor was involved with the murders of the victims in the University of Idaho murders. I admit in part this matter. Specifically, I admit I stated publicly the results of a tarot reading. The tarot reading revealed that the professor was involved with the murders. Admitted, admitted. Where else do you go? Admitted, admitted. Admit that plaintiff did not have an affair with victim Gonsalves. Request, I deny this matter. The plaintiff has not proven that she did not have an affair. The plaintiff's discovery attempts to gather information from the University of Idaho was limited and manipulated. Unless otherwise proven, I believe the tarot reading to be correct in its entirety. Admit the plaintiff was not involved with the murders of the victims. I deny this matter. The plaintiff has not proven that she was not involved with the murders. Unless otherwise proven, I believe the tarot reading to be correct in its entirety. Admit that the only basis for your statement that plaintiff had an affair with victim Gonsalves is your spiritual research, intuition, and instincts. I deny this matter. I also used investigative skills. Public information about the case, public information on the University of Idaho website, logic, and behavior analysis based on the actions of the plaintiff during this civil case. Wow. That's wow. Wow. Just wow. Yeah, you guys, I don't have a choice. Chat, I have to. We have to go code green. We have to go code green. That's the only option we have. We have one option. We have just one option in this life, and right now that option is code green. Motion granted, cuz the fucking audacity. Wow. These attorneys, when they received these back, to be a fly on the wall in that office. Admit the only basis for your statement the plaintiff was involved in the murders is your spiritual research, intuition, and instinct. Deny. I used investigative skills, public information, logic, the University of Idaho website, and behavior analysis based on the actions of the plaintiff during this civil case. I mean, after the statements were made. Admit that you have never been to Moscow, Idaho. I admit that I've never been to Moscow. Admit that you've never been to the state of Idaho. I admit that I've never been to the state of Idaho. Admit that you are not aware of any physical evidence linking the plaintiff to the murders. I deny this matter. There's plenty of evidence to be discovered during the civil discovery process or criminal trial. Discovery's over, boo. Admit that you are not aware of any physical evidence showing that plaintiff had an affair with the victim, Gonsalves. I deny this matter. There's plenty of evidence to be discovered. Then where is it? All of you in the chat that are like, logic, I don't think that word means what you think it means. Correct. Mind8 said she doesn't have a lawyer, right? No, she's acting as her own lawyer. She should have consulted her cards. They probably would have told her that this was a bad idea, because this is a bad idea. She's going to be found liable without going to trial. I can't imagine any other result. Admit that you never said plaintiff communicated with Brian Kohberger about the murders until after Mr. Kohberger was arrested on December 30th. I deny this matter. Before Kohberger was arrested, I referred to him as Schofield's second option for a hitman. But not by name. You said she had a second option for a hitman. Admit that you never said plaintiff had access to a white Hyundai Elantra until after law enforcement publicly stated they were looking for information about a white Hyundai Elantra in relation to the murders. Admitted. Well, that was easy. Admit that you've never communicated with Jack Decor. I cannot admit or deny this matter. Many people have anonymously contacted me by way of electronic communication. It's a clever answer. It's actually probably a factual answer. It's like anything could happen. I haven't knowingly communicated with them. Same answer as to Brian Kohberger. Admit that you have no written information showing plaintiff ever met Xana Kernodle. I cannot admit or deny. I have not received written information showing plaintiff ever met Xana. Discovery is still pending. Public information from the victim's social media may show that plaintiff met Xana. But you don't have that information. The question says you have no written information. It's like, but I might. Kind of. Admit that you've never received any information orally from another human being showing that plaintiff ever met Xana. Admitted. And this goes on for each and every one of the victims, and the answers are the same. Admit that you read and received a cease and desist letter from the law firm dated November 29th, 2022. Admitted. Admit that you received and read a cease and desist dated November 29th and continue to state publicly Rebecca Schofield had an affair. I deny this matter. I did not receive November 29th cease and desist until December 8th. It says admit that after you received the letter dated the 29th, and she's playing games on the date. She's playing games on the date. That's not going to work. That's an admission. Admit that you never received a cease and desist Admit that after you received and read the cease and desist, you continued to publicly state that the professor was involved in the murders. I deny this matter. I did not receive it until December 8th. Received the letter dated after you received it. Oh, that's going to be deemed admitted. Admitted. Admit that you received a cease and desist letter dated December 8th. Admitted. Admit that after you received that cease and desist letter dated December 8th, that you continued to state these things. Admitted. Admit that after you received the letter dated December 8th, you continued to state publicly that she was involved in the murder. Admitted. Received the cease and desist, kept saying what she said. Admit that you are aware that on or about December 27th, Moscow police issued a press release about the murders, stating at this time in the investigation, detectives do not believe the female associate professor and chair of the history department at the University of Idaho suing a TikTok user for defamation is involved in this crime. Admitted. Admit that after you became aware of this release, describing the requests, you continued to state plaintiff was involved with the murders. Admitted. There's no issue to fact. There's no issue to fact left. So this, I think, will resolve as a matter of liability. We've read the cease and desists in the past. This is the press release, which we've seen in the past. And then these are all provided via flash drive. All of the TikToks are provided to the court on flash drive. So let's swoop-a-doop to the request to amend the proceedings for punishment damages, for punitive damages. Let me pull that up because somehow it wasn't just right there. Come on, where are you? Motion for leave to amend complaint to add punitive damages. We're going to zoom with this too. It's going to be a lot of the same. So let's go. Oh, this TikToker. This is why these cases are so hard, man. Professor by and through attorneys leave to amend the complaint to add punitive damages and supporting factual allegations against TikToker. Attached Exhibit A is the proposed amended complaint. Attached Exhibit B is a red line comparing the proposed amended complaint to the complaint. The motion is supported by a memorandum filed in support. Let's go look at the memo real quick. We can look at the red line real fast. If we want to, let's zoom. Love a good red line. Let's see. Here's the red line. After receiving a cease and desist letter on December 18th and 19th, posted more than 20 new TikTok videos falsely stating the professor was involved with the victim and the professor's motive for the murders was to keep the victim from making their relationship public. TikToker became aware that on or about December 27th, the police department issued a press release. So this is adding in the things that the TikToker has admitted to show that not only was the TikToker aware, but that the TikToker doubled down. And so these red lines are the things that are that the plaintiff is asking the court to allow to be added to the motion. Gouliard continued to state the professor was involved even after becoming aware of the press release. On February 8th, TikToker published a YouTube video in which she falsely stated the professor has photographs, videos, and messages from the night of the murder during the murder on a collaborative book literature app she used to collaborate with people she had help her plan and execute the murders. What? In that February 8th YouTube video, TikToker falsely described how the professor first mentored then began an affair with one of the students. On or about June 9th, 2023, TikToker participated in an interview posted on YouTube program Nerd Report, in which she said the arrest of Brian Koberger did not change her mind about the professor's involvement in the murders. She also falsely stated the professor contacted Koberger on a whim on the day of the murders. On or about October 14th, 2023, TikToker posted yet another YouTube video stating the professor was responsible for the murders. TikToker has admitted she has no physical evidence or written information supporting her false statements that the professor was involved with the murders or had an affair with one of the victims, and she has admitted that no person provided her with any such information orally. Oh boy. Punitive damages as provided for under Idaho code. So this is above and beyond reckless disregard, right? Chat. A book literature app is where I admit to all of my murders. Angela, that's a funny comment. It, it doesn't even make any sense, but I'm sure that they're just quoting what the professor said. Professor has photographs, videos, and messages from the night of the murder during the murder on a collaborative book literature app she used to collaborate with the people she had helped her plan and execute the murders. Ma'am. Jicky in the chat said, this is so frustratingly bizarre. Yep. Did the professor lose her job? No, the professor did not lose her job. This is a per se case. Damage to reputation is what they're leaning into. So let's take a look. Is this? Oh, we've started in New Mexico. So hold on, let me back. They are 40 seconds into hearing in New Mexico. Let me pause that real quick because court is going to be starting. We're going to zoom through the rest of this real quick. I can't leave you hanging, and then we're going to go to court. It's time to go to court. But Professor Schofield requests leave of court to file her proposed amended complaint to add a prayer for punitive damages with supporting factual allegations. This court's scheduling order set a January 12th deadline for filing such a motion for leave to amend. Thus, this motion is timely. Defendant's responses to the request for admission show that she has no facts to support her extreme and outrageous assertions that the professor had an affair with a student and planned, initiated, ordered, and executed the murder of 4 University of Idaho students. Gouliard has also continued to make and participate in YouTube videos repeating these false statements. Punitive damages are appropriate. I agree. So this is going to be reiterating what we've already seen. Here's the conclusion. The primary purpose of punitive damages award is to deter similar conduct from happening in the future again. They are punishment damages, like baby did a bad thing. They are you suck damages. Like, don't ever do this again damages. TikTokers' false statements on TikTok about the murders and the professor's role in them were designed to gain notoriety and attention for TikToker. She admitted as much on June 9th in a Nerd Report interview where she explained how she got traction for her post on unsolved crimes. TikTokers' conduct is precisely that which punitive damages were designed to address. The professor has set forth more than sufficient evidence for the court at this stage to find that she has a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. The argument here, just to put a bow on what's going on, the TikToker has admitted she has no factual basis whatsoever to believe the statements that she made. She was told that those statements were false and continued making them. She was shown contrary evidence in the form of a police department press release to show it was contrary to fact, and she persisted. She continued. Damn it, Swoop. My Swoop. Swooped. Oh, we're professionals here. I was in the middle of a rant. She was shown receipts, proof, timeline, fucking everything to show that this professor was not involved in the things she said she was. And instead of stopping making those statements and taking down the videos, she continued to make those statements and said that it was based on her own intuition and now logic. And that is why they are asking for punitive damages, because she would not stop. And if Attorney Olson does not stand up there and say that this defendant lacks receipts, proof, timeline, screenshots, fucking everything, it is a missed opportunity. So we will see what the court decides. I hope that there is oral argument on this motion. If there is, I will attend and tell you about it. I hope that we see the court at this point, who has given this TikToker every single ounce of grace and time and guidance, that we will see this court find liability. It's all they can do. And look, there are times as a lawyer where you have to see that when a court is ruling in favor of the opposing party on smaller matters that at the end of the day aren't consequential, it's because they are going to rule on your favor in the bigger matters. And I think this court is leading up to the fact that this might be the way that it is, that they find liability here without liability for defamation going to trial. But no one can say this court has not been patient, courteous, professional, and has given this TikToker ample opportunity to defend themselves in this case. And what they have done is admitted to all of their defamation and say, but it was based on their own intuition. And that is not going to fly in a federal court on a defamation case. So with that, we need to go to New Mexico. Pack your bags quickly. All aboard, hands and feet inside the airplane. We will be tray passing champagne. Let's go to New Mexico, y'all. Court has begun live in New Mexico. I'm sure at some point the court will take a break and then we will be able to catch up. Let's see if I do this. This is coming in from the court's own website. Thank you to the court in New Mexico. We've got Judge Sommer on a motions hearing in the Rust case. This is the part of the Rust case with the armorer, Hannah Gutierrez-Reed. We are here for motions hearing an argument because somehow the prosecutors turned over attorney-client communications between defendant armorer and their attorneys to Seth Kinney, the head of the Armory House, where the bullets may or may not have come from. This is wild. Wild. So let's go to New Mexico. They're doing all of this by Google Meets. And we're going to be in court for the afternoon. Court is in session. We're going back to my normal lights. We're going back to my normal lights. Let's go.
All right, good afternoon. The matter I'm calling is D101CR202340, State of New Mexico versus Hannah Gutierrez-Reed. Parties state their name.
Good afternoon, Your Honor. Carrie Morrissey on behalf of the state of New Mexico.
Good afternoon, Your Honor. Jason Bowles and Todd Bullion are here, and so is Ms. Gutierrez-Reed.
All right.
Lawyers, if you're using your laptop camera, get a laptop stand and put your camera at eye level so you are not looking down at it.
Very good. All right, so we have 3 motions before the court today.
Your Honor, if I can just make a record with regard to one of them.
Let her
in
talk.
terms of timeliness.
Just let the court tell you what motion she's here on. Let the court, ma'am.
Sure.
And I want to be clear. Is the court
This is the
not hearing the
prosecutor.
motion to sever and the motion to dismiss today?
You did the notice of intent to take longer, the time allowed. So I will address that at the end.
Okay, in terms of the defense response to my motion in limine to exclude the OSHA report, Mr. Bowles filed this yesterday. He didn't email it to me, so I got his response over just standard Odyssey notification 2 hours ago. So I am not prepared to argue that. If he had emailed me his response yesterday, I would be prepared to do that, but I can't do that with just 2 hours.
Okay.
All right, that's your motion on OSHB.
Correct.
All right, so we have 3 motions that we're going to hear later. I'll address maybe more, but we'll address those. So today's 2. Did you wish to do a response, Mr. Bowles, on that?
On Ms. Morrissey's comments?
Yes.
Yes, Judge, I understood from the last hearing that the court told us the court would set these Thursday, and the court was very clear that we don't have time. We have to move quickly, and trial is set for February 21st. So we are prepared to argue all the motions today. We're prepared to argue the ones the state hasn't responded to, and we thought that's what the court had ordered the last hearing. So we're ready.
The court ordered that in the last hearing because the court it did not occur to the court that those motions were not expedited. I would have thought that you would have done an expedited motion at this time. I hadn't seen your motion to
Why?
to sever, and I hadn't really seen your motion to dismiss. I just knew it was filed, and I had assumed, given the closeness to the trial date, that you would have made them expedited so that Ms. Morrissey's response would have been expedited. But you did not, and under the rule 1-125-120, she gets to respond within the appropriate time. I will address those at the end. I don't want to address them up front. I'm giving you a
Y'all,
time
hold
frame
on.
within which to do those motions. Now, with respect to the
There we go.
motion limine for OSHA, yes, I said we were going to do all these motions.
Sorry about I keep trying to move the closed captioning and it won't move. At least there is closed captioning. Glad for that. So the court said, I thought the defense would file these expedited motions. It would expedite the prosecution's response. And you didn't file them expedited. So the prosecution gets their time to respond. So why didn't you file them in an expedited fashion? So the court's like, that's on boo, that's on you. But the court did say last hearing, from what I have looked at in these motions, that they were all going to be argued today. So I wonder if the defense believed they didn't need to file them noticed expedited because the court said they were going to be heard today. I think this is just a miscommunication. I think this is a miscommunication, and I think that the court telling them that should have said file them expedited. If that was the court's expectation, we need to voice those expectations
on today, but you cannot be filing a response and getting her the motion in the morning.
That's
so
fair.
We're not going to hear that today. All right, so let's start with, let's do those two motions that we are going to hear today. And those are the ones that were filed by you on the 16th and which the state did respond to. So you can take them in either order. They were filed on the same day.
Mr. William is going to address those, Your Honor.
So they're only hearing 2 of the 3 motions today, and then the court's going to address when they're hearing the motion to dismiss. So we might not even get to the motion to dismiss today. Rude. I hate the color of this wall.
Judge, I would ask to take the argument concerning the motorcycle accident first.
That's a motion in limine.
It's fine.
Judge, the argument here is a pretty straightforward one.
Trial is starting next month. So they are arguing their motions in limine, arguing what evidence will or will not come in at trial. So this is regarding a previous motorcycle accident with Hannah Gutierrez-Reed.
This is a other act that we believe the state intends to utilize to prejudice Miss Reed in her case. In the government's response, they indicated that they were not going to use this in their case in chief, but they may try to utilize the evidence if the door was opened. They didn't advise as to how any type of door would be open, but they said we may use it in that fashion. There is a case I provided the court.
I need to interrupt for one moment. Mr. Bowles, pursuant to the Supreme Court order, you need to be on video during the hearing. Thank you.
The other attorney, it sounds like, went off camera, probably because he was explaining to Hannah Gutierrez-Reed what was happening because his client is sitting there. But the attorneys are required to be on camera during the hearing. So this court does not seem does she seem thrilled with the defense this morning? Because I'm going with no.
Judge, there's a case I located and provided to the court today, State versus Fernandez. Particularly important in that decision is paragraph 20, which discusses the applicability of 11404 to evidence coming in through a door being opened through other testimony. The government hasn't addressed the applicability of 404 to this evidence at all, and they don't get to dodge the question by saying, well, it may come up if it's relevant through opening the door.
I mean, but it may come up if it's relevant through opening a door. I don't know how else. Look, I don't love this prosecution team, but I don't know how else you get to it. 404 does not mean not found. 404 is prior acts evidence. We talked a lot about 404 in the Depp v. Heard case, but Lyndon said, less than pleased, professional but chilly. Yeah, the judge is not impressed at this point. There's been a lot of litigation filed since the first of the year. It's January 25th, and it's been like a deluge of litigation over this case. I'm grabbing my rules of evidence.
That case, which is a Supreme Court case, is crystal clear that 11404 analysis is still done on other evidence or information that's going to be presented through a so-called opening of the door. And under 404, the government has to provide specific reasons as to why the evidence would be allowed, which they've not done. Furthermore, Judge,
Damn it.
if I could...
My rules of evidence
share my screen.
Where did they go? Sir, my rules of evidence. Objection 404, my 404.
Can the court see the document I've pulled up?
Yes.
Okay. Judge, this is a motion response filed in June of 2023. It was the state's response to dismiss the first amended indictment. And on pages 17 and 18 of that document, the government referenced this motorcycle accident and said, Ms. Gutierrez has previously been sued for providing the keys to her motorcycle to an intoxicated person. Witnesses in the current case will testify that Ms. Gutierrez was drinking heavily and smoking. It is, and then they go on to say it is likely that defendant Gutierrez was hung over when she inserted a live bullet into a gun. And
I'm going to back this up because I feel like I was distracting. This is the core of their argument over a prior lawsuit that Gutierrez Reed was involved in and whether or not she was intoxicated. But I can't believe I can't find my rules of evidence. I'm going to have to go find those.
23. It was the state's response to dismiss the first amended indictment. And on pages 17 and 18 of that document, the government referenced this motorcycle accident and said, Ms. Gutierrez has previously been sued for providing the keys to her motorcycle to an intoxicated person. Witnesses in the current case will testify that Ms. Gutierrez was drinking heavily and smoking. It is, and then they go on to say it is likely that defendant Gutierrez was hung over when she inserted a live bullet into a gun. And they go on to say that
the prosecution in this motion argued that they would go on to show that these things were going on with Hannah Gutierrez Reed. Why does he keep saying the government? Because he is talking about the prosecution. This is the government's argument. So, yes, Cheryl Ray, I did clean and I put it back on the wrong shelf. I will have to go 404 my rules of evidence later. One of your kids probably stole it. The kids these days love the rules of evidence. With my teen, it's very possible. So this is the government saying that they would likely have witnesses that will say that Hannah Gutierrez Reed was hungover and was partying the night before. The defense is arguing to keep some of this stuff out.
Has a history of reckless conduct that results in the loss of human life. So, Judge, that by definition is a propensity argument, and they stated their intention to make that argument over 7.
Lena, this is exactly what the defense is arguing against. Lena said in her comment, she's been drunk before, she was probably hungover this time. That's propensity. You can't show, oh, because they did this thing in the past, they did this thing now. There has to be more evidence in that. That's the argument here. What's the street value of black market federal rules of evidence? High. It's high. Everybody wants those federal rules of evidence.
Months ago. Any arguments that we hear today about, well, it might come up if the door is open, I will put to the court as a pretext to use this information, which they have planned to use at least since June of 2023. The government admitted in their response that there's no relevance to this other set of facts, and it would also be incredibly unwise to get in to that set of facts in a trial, to essentially have a trial within a trial about an unrelated incident that's going.
Oh, are we well and familiar with a trial within a trial? That we don't need a trial about whether or not she was intoxicated unless somebody saw it.
And to distract the jury and prejudice my client. Additionally, Judge, reference has been made by the prosecutors that the case had settled for a particular number. That type of evidence and argument is specifically barred by 11408 because it tends to distract the jury from thinking about what's actually going on in a case. Because if they hear that something has settled, they assume conclusions about the facts without that being warranted. So there's no use for this evidence. It's highly prejudicial. There's no 11404B exception, and any argument that it can come in through some other way doesn't avoid the application of 11404. And there's simply.
So in the federal rules of evidence, it's 404. It's clear that in the New Mexico rules of evidence, they added 11s before everything. So it's 11404 and 11404B. It's all still 404.
No 404B exception, and there's no conceivable way that a balancing examination under 403 would allow this evidence to come in. So it should be excluded, Judge.
Response.
Excuse me, prosecutor. The judge said response.
Sorry. Your Honor, the problem with the motion in limine is we don't know whether this is going to be relevant until Ms. Gutierrez is on the witness stand.
The court can rule that it's not coming in unless the door is opened.
And I have indicated to the court that I am a professional and I won't blurt anything out in front of a jury if I.
Great. Question, Hannah and Alec are charged separately. Jen, yes, they are.
I have reason to believe that this has become relevant and admissible. I will ask to approach the bench, and all conversations about this will take place outside of the presence of the jury. Beyond that, I'm not sure what I can do. I will also point out to the court that when I say that this may be relevant to Ms. Gutierrez's character for truthfulness, that's not controlled by 11404B. So that case that Mr. Bullion provided, by the way, Your Honor, about an hour and 15 minutes ago, it is not on point in terms of my response. My response is, it may be relevant to her character for truthfulness. I don't know. She hasn't testified yet. In addition to that, it may come in as impeachment under 11607, depending on what her testimony is. And I know that Mr. Bowles and Mr. Bullion know that. So I am agreeing that I will follow the rules and I will behave myself. And if I think that for any reason this is appropriate, we will have a bench conference about it so that the court can make the appropriate ruling.
And that's appropriate. She's like, I can't know what's coming up. I can't know what's coming up until your client testifies, if they testify. These attorneys are not thrilled with each other.
Any reply?
Judge, I don't see how a completely unrelated incident could possibly bear on my client's character for truthfulness. I can't think of anything that she would say that would somehow make this other incident
what opens
relevant
the door
in any way, shape, or form to her character for truthfulness.
Somebody's going to ask her if you ever killed anybody before. It's going to be wild. Oh, the court's going to rule. Okay, good. The court's like, yes, thanks. Ruling.
Following ruling. Based upon the state's response, the state identified it as a plan to address her issue if she testifies regarding her truthfulness. It was not, it says the state does not intend to introduce it in their case case in chief. So
I'm going to hold
I'm
the
taking
state to
that
that.
at her word that that's not going to happen.
Right.
Secondly, 607 impeachment, I don't know how that would be, where it would come in, but it would come in under 11608 with respect to truthfulness, if that is the case. So this is how I'm going to rule. I'm going to deny your motion
It just depends.
to prohibit the use of the motorcycle accident reference, but that is for purposes of what Ms. Morrissey said she was going to do. And that was,
I'm going to answer some questions while we're doing this, just because this judge moves fast. I love her glasses. Hannah is out of custody and has been out of custody. No, not homeless and toothless. Or is anybody watching Real Housewives of Beverly Hills? Not toothlessness, not toothfulness, truthfulness. Let's see. She said bench and I heard bitch meeting. I mean, sometimes it feels that way. Tripping Gauntlet said all of them are lacking in any spark. This is what court is normally like. This is exactly what court is. This is very typical and traditional court procedure. This is a normal day in court.
Was the truthfulness aspect of it. That was going to be her false statements to law enforcement, that was not her car. And that, and remember, all she can do is ask the question. This is a specific instance of conduct. She has to ask the question and take the answer. So
there was new information in there. Who caught it? Let's back up real quick. This is why it's going to be relevant, not the hangover.
But that is for purposes of what Ms. Morrissey said she was going to do. And that was the truthfulness aspect of it. That was going to be her false statements to law enforcement.
Hannah Gutierrez reads false statements to law enforcement with regard to the motorcycle incident that killed who I believe was her boyfriend, because she had given the keys to, I believe it was her boyfriend at the time, who was intoxicated and lied about it.
Was not her car. And
I think it was a motorcycle.
And remember, all she can do is ask the question. This is a specific instance of conduct. She has to ask the question and take the answer. So if the defendant does elect to testify, the court orders the state to alert the court and defense of its intent to offer this evidence via a requested bench conference before attempting to cross-examine her on it. And then at that time, based upon what's been going on,
Angela,
it may be denied. But at this point, I sense that it should be allowed for purposes of the truthfulness or untruthfulness. She can ask about whether she lied to law enforcement officers about whether that was her vehicle, and whether she talked about the insurance payment. I'll have to get into the specifics on the proffer on that. But
Matt Z, what is Andy from The Office?
In any event, that's
for those of you just listening in the background. Matt Z's super chat was who lost a tooth on The Hangover, and I felt like we were playing a game of Jeopardy. So who is Andy from The Office?
That's where we are today on the 11608. So please prepare an order on that, Ms. Morrissey, with the very specific crafting that I have allowed to do.
Yes, Your Honor.
It must be so nice for these attorneys to be able to go back and watch exactly what the judge said to craft the order instead of furiously taking notes and then asking the court clerk.
Mr. Bullion?
Judge, with respect to the other motion, which regards written notice under 11404, B, we are currently less than 30 days from trial. We've received no written notice. In the government's response, they said that they may give written notice if the court provides a deadline, and that's kind of avoiding.
Doesn't your code have a deadline?
The problem here. 11404B requires that reasonable notice be provided. We are currently close enough to trial that if notice were to be provided today or tomorrow or at some other point about other acts evidence, we would be too close to trial for that to be reasonable. We won't have time to evaluate.
What does your case law say about reasonableness, though? Like, what timing does it give it?
So this is about 404B
notice.
We won't have time to make motions upon it. And the rule specifically contemplates that the parties have sufficient time to review
30 days
any
is a
kind
lot
of
of
other
time.
acts evidence, bring motions about it, make plans as to how it will affect their trial strategy. We're close enough to trial that we can't do any of that. So we're asking for
I don't know. I feel like 30 days is more reasonable than like 2 days. So we'll see.
Prohibition on any 11404B evidence, Judge.
404B is other bad acts evidence. So
Ms. Morrissey.
Well, Your Honor, I think a prohibition would have been appropriate if the defense had simply filed a motion asking.
Oh, these attorneys are so angry with each other. Well, Your Honor, if the defense had done this, then we would have done this. The defense is asking for notice of 404B evidence, other bad acts evidence, other crimes, other character evidence, other shit that might come up that the prosecution's aware of that they need to turn over to defense. You have to give reasonable notice. They're arguing over whether 30 days ahead of trial is reasonable or not. The prosecution comes back in with, well, if the defense, oh, I can't wait to hear what she has to say.
Of that. So we're asking for a prohibition on any 11404B evidence, Judge.
So they're asking the court to block all of it. No 404. There's not been notice.
Well, Your Honor, I think a prohibition would have been appropriate if the defense had simply filed a motion asking the court to set a deadline for 404B notice. In absence of a deadline for 404B notice, the rule controls, and the rule says prior to trial. The rule does not support Mr. Bullion's arguments this morning. If the court wants to set a deadline, I will happily adhere to that deadline.
She's like, prior to trial is like the Friday before trial starts, boo-boo. You didn't even email me a motion that you wanted to argue today when you filed it 2 hours before the hearing. So the defense filed a motion and didn't give the prosecution or a response and didn't email it directly to the prosecution. So they didn't even get it till like an hour before the hearing. And so they're like, it says before trial. Trial hasn't started yet. So I don't have to give you shit. These attorneys do not get along. Yikes.
Please keep in mind, Your Honor, Mr. Bullion is saying today that this court doesn't have enough time to address 404B written notice when there's a statute that says anytime before trial, but they are filing as of January 18th, full motions that are 8 days past when the court indicated the motion's deadline had expired. So Mr. Bullion's talking out of both sides of his mouth. I will.
Who thought she was going to say talking out of his ass? Who thought that that's what was coming? Oh, these attorneys are not thrilled. Trial's going to be interesting.
When the court indicated the motion's deadline had expired. So Mr. Bullion's talking out of both sides of his mouth. I will ask the court,
all of you, to
establish a deadline if the court thinks that's appropriate. I will adhere to the deadline. I would also ask the court, though, we desperately need guidance in terms of deadlines so that people know what they're doing and we're not getting surprises. The motion to dismiss filed by the defendant is filed 6 months after that issue arose. 6 months.
What? That's new information. Oh. We need to read the motions. We're going to read these motions after the Murdaugh motions. The motion to dismiss is based on the turning over of evidence to the witness. I thought this just happened. 6 months after it happened? They waited 6 months to file this motion? Okay, I'm less pissed at this prosecution team. This is why I want to watch it happen in court, because then it's like, you might be team defense at the beginning, and then you're like, wait, you held on to this for 6 months? Now I've got questions for you. Oh boy.
So obviously, I'm going to make all those arguments in my response. I'm going to ask the court to deny it because it's not timely. But please, Your Honor, we've got to have some deadlines. We've got to know what is happening, when things are due, and when the time has expired.
We need to know. Because clearly the time has expired and the defense is still filing motions. If the defense is filing motions 8 days after the motion deadline, I'm surprised the court didn't just throw them out. No one's pleased. Everyone's mad.
Mr. Bullion?
Judge 11404B3 states verbatim, notice in a criminal case. In a criminal case, the prosecution must, and then in subpart A, provide reasonable notice. Miss Morrissey cannot shift the burden to the defense and say, well, we should have asked for a deadline. The rule controls, and the rule specifically places the burden on the government in a criminal case to provide reasonable notice. And we are at a point in time where we do not have reasonable notice for any other type of 404B evidence.
He's making the motion now to preserve the motion, saying that 30 days is not reasonable.
Your Honor, may I respond with regard to the part of the rule that clearly indicates that we have up until trial? And yes. Not only do we have up until trial.
No, you've already responded.
All right,
okay, you had your opportunity. All right, so this is what I'm going to do. I'm giving deadlines. All right, I realized last time at the status that you all, I thought were, because you litigated so many things, I thought the substantive motions were over. But
I thought y'all had it figured out. Clearly you don't.
Then I got 2 substantive motions. Motions in limine, I take up just before trial, but you know, it's getting to the point where I might see more than I had bargained for, so to speak. So here are your deadlines.
The judge, enough is enough. Enough is, I thought y'all were done. So I'm going to set some deadlines so I can say, are you done now? So the judge is saying the motions in limine should be all that's left, but there are still substantive motions, including this motion to dismiss.
State has two motions to respond to. That's defendant's motion to sever and to exclude mention of other alleged bad acts. Which one is that?
Your Honor, I think the 2 motions I need to respond to are the motion to sever and also the motion to dismiss, or in the alternative, motion to
That's it, motion to dismiss. Okay. Motion to dismiss. All right.
That's what I thought.
So your deadline for your motion to sever and your and to exclude mention of other alleged bad acts is by Wednesday. But did you already respond to the alleged bad acts? You did. Okay, so this is what, okay, I'm sorry.
What about the MTD?
You have until then. January 31st is your deadline, the motion to sever. February 2nd is your deadline on the motion for dismissal. Okay? Now, if you're going to bring in additional notice of evidence, you also have until February 2nd. Okay?
Yes,
Do you
Your
have any
404.
questions on that?
I do not, Your Honor.
All right. Now, the defense reply deadline on the state's responses to those 2 motions, the motion to sever and the motion for dismissal, is Friday, February 9th.
For both?
Then, if the state files another notice of bad acts, then you have also that same deadline, Friday, February 9th. For your motion in limine, and then the state will have till February 12th to respond to the defense's motion in limine. All pending motions are going to be heard on February 14th, beginning at 1 o'clock. So that will be the 2 pending motions. It will be
there are so many things in court that
any
day.
motion in limine if the state files another notice a prior bad act.
Y'all, February 14th.
And it will also be the OSHA motion.
So the OSHA motion, the 404 is in the motion to dismiss, right?
There are no more motions in limine allowed. and there are no more substantive motions allowed.
Done.
The only motion in limine that will be allowed is the one I just accepted, and that is if the state files a prior bad act notice and you all wish to do a motion in limine. Do I need to run through those dates at all?
No, I got them. Thanks, Your Honor.
Not on behalf of the state, Your Honor.
No, Your Honor.
Not on behalf of the internet, Your Honor.
Okay. All right. So this should finish the concern about scrambling for time. All right. All right. Thank you.
Thank you.
I'm not going to go ahead and Ms. Morrissey do an order on the prior bad act motion in limine that I've given you a deadline. Okay.
Yes, Your Honor.
All right. Thank you. All right.
Thank you.
We are in recess.
Thank you.
Boo! Boo! We didn't get to the motion to dismiss and are gonna have to come back for the motion to dismiss on February 14th. Ugh, I am so sad. All right, well, I guess we'll be back February 14th in New Mexico. So that's a bummer, but we'll be back February 1st for Alec Baldwin's arraignment. So we can do that. I mean, he's filed his notice of speedy trial. So we'll be back for that on February 1st. So we've got a lot of court on February 14th. It's going to be busy. And then this is going to start trial. I don't know who is going to be streaming the trial, but we will figure it out and we will stream that trial. So Valentine's Day, we're all going to be here together in court. There's a big hearing in the Scientology case that day as well. So we will keep an eye on that from afar, but we will be in court in New Mexico on Wednesday, Valentine's Day. What I'll probably do is premiere the podcast and then do an afternoon court session with y'all on February 14th. So y'all figure out what you want to bring for the class on February 14th, and we will be here together on Valentine's Day. There's going to be an Adelson hearing that Monday, so we'll probably cover the Adelson hearing either on Monday or Tuesday. I just have to figure out what we're doing around here. That week is going to be busy, and then trial starts the following week. The Hannah Gutierrez Reed trial starts the day after the sentencing of Ruby Franke and Jody Hildebrandt. We're just gonna be busy. So let's summarize what happened in court real quick, and then we're gonna just go to Q&A, and that's what we're gonna do today because we're back in court tomorrow. So in New Mexico today, the lawyers are clearly annoyed with each other. The court finally set some deadlines for notice of prior bad acts evidence and prior uncharged acts evidence under Evidence Rule 404B. The motion to dismiss based on the prosecution disclosing that information from defendant and defense attorneys. We learned through the prosecution's argument in court today that incident happened over 6 months ago, and the prosecution is arguing that the motion is untimely. I still want to know how that happened. So we're going to go over the filings of the motions, and then we'll be back in court in New Mexico February 14th for the argument on the motion to dismiss and the rest of it. All that was decided today is that the prosecution can't bring up evidence of Hannah Gutierrez Reed lying to police in an unrelated incident unless she testifies and it becomes relevant, and they can use it potentially to show her character for truthfulness, but that will be determined by the court at that time. So, oh my God, the entire sky just opened up here in Middle Tennessee. Wait for the thunder and the lightning because that's surely coming. So with all of that, not a lot decided today in New Mexico, but we got to see how frustrated it seems everyone is with one another. And sometimes that kind of court hearing is just sassy. So with all of that, let's get to questions. We have lots of questions. Let's go to Q&A. I was sitting here going, why did the sky get so dark? What is going on? As my mom says, the bottom fell out. Yeah, everything just fell out of the sky. Champagne and chocolate covered strawberries, February 14th, law nerding. We're doing lots of law nerding on the 14th. Question, any chance you could put up a calendar on all the trials you're covering? DeBeast Mama Bear, we are working on putting a calendar function in the app. The thing is, those are subject to change. The app is the best place to stay in the loop on that because subjects change and topics change and time changes so much. Question, thoughts on Harvey and Wendy being prosecuted? I don't know if Harvey's going to be prosecuted unless something happened overnight. Thoughts on Wendy being prosecuted? I'm going to do a whole podcast episode about the type of immunity Wendy has. I need to look into that a bit more. I saw a number of questions about Murdaugh. I talked about it at the top of the show. The Murdaugh hearing tomorrow is not going to be live streamed or recorded in any way. So we're going to have to wait till Monday to get into Murdaugh. And then when we have time, we'll get into Courthouse Becky's emails. So let's see. Let's continue on. Do we need to bring flowers and chocolate for February 14th hearing trial? Do what makes you happy. Just do what makes you happy in your house. There will be flowers in my house. Tomb Raider collection releases the 14th too. I had no idea. Let's see. Who's bringing cupcakes? Everyone needs to bring cupcakes. Everyone needs to bring cupcakes. Are we going back to Idaho for the rest? We're going back to Idaho tomorrow. There's not really too much more in those motions with regard to the TikToker. I think we wrapped them pretty thoroughly. I can't wait to see what the court says. The TikToker hasn't responded to those motions, and I don't know if they will. So we will see. Judge's voice is so similar to a coworker that it's kind of alarming. That's funny. I demand a partial trial refund. Partial travel refund. Will we be exchanging Valentine's Day cards, candy? You guys can discuss amongst yourselves. I think we'll just be trading heart emojis in the chat is what we will be doing because, the internet doesn't let us like message gifts to one another quite the same way. We need the little drones, the good ones from the Hunger Games, like the little drones that can just like drop off presents. Wouldn't that be fun? Maybe kind of creepy because how would they know where you are? But also could be fun. A little bit of both. February 14th is Ash Wednesday. Time for a king cake. I did not even realize it was Ash Wednesday. It's terrible of me. Thoughts on why Donna Adelson's attorney went on a YouTube channel, Surviving the Survivor, recently? I have no idea. I have no thoughts. I have not seen it. Making statements to any type of media during a pending trial is always an interesting choice, and we've seen it come back to bite people. So I have not seen it. No seeing these documents today. Which Yellow Pill, which documents? Because we've been through a bunch of documents today. Just not those. The motion of the OSHA. The OSHA motion will come up. The OSHA motion was, and I covered the OSHA motion ages ago, but the OSHA motion was scathing about the safety on set. So I'm not surprised there's a motion in Lemonade to keep it out. Mannix said, I don't understand. I thought Baldwin was cleared. Why is he being charged? He is being charged on new evidence, is what the prosecution has said. They were doing additional forensics, and now they have charged him. So that I saw somebody said the DA is doing a press corps. Which DA? There's too many cases. And which DA? Because I truly don't know. Saying OSHA motion sounds like shaking a cocktail. The motion was in the ocean yesterday in California. I saw a lot of people posting about the earthquake that was out there. Shows the ineffective squash blossom of the New Mexico. Shows the ineffective squash blossom the New Mexico courts are. I think if they didn't file it properly, I'm not surprised. This was my entire vibe as a research attorney. If they didn't file it properly, you can't hamper the other side. It's like you didn't file it expedited. The other side didn't have to respond expedited. You can't hamper their ability to respond because you didn't do what you're supposed to do. I understand the court being like, you should have filed it expedited then. Question, why government, not state? I mean, it just really depends. Those are jurisdictional. I've been called both. I've been called lots of things on the internet, but as a prosecutor, some people said the state, some people said the government. Nobody said the crown. I didn't realize that if I was in like Canada or the UK, I would get to be a crown prosecutor. Like that would be kind of fun. a whole different vibe. But I think it really just depends on jurisdiction. Government and state can be used synonymously. However, I tend to find it to be more specific when the government refers to federal prosecutors and the state refers to state prosecutors. I find that that is the more specific terminology, but lawyers will use it synonymously and everybody knows what they mean. This is a state level prosecution. Will you please cover the current Kat Von D tattoo copyright trial? She tattooed a photograph on a friend and the photographer is suing for copyright. I will cover it when it resolves. I just saw some articles about it. We had done a tattoo, God, it must have been over a year and a half ago, where we covered tattoos and copyright and some like Disney intellectual property or Star Wars intellectual property. When you look at things with intellectual property, some courts have determined tattooing is not sufficient to change the work enough. But that case has been pending. The Kat Von D case has been pending forever on a famous photograph. But it is an issue. Is it just a recreation? So we've seen the courts in the recent, what was it? The Prince photograph painted by Andy Warhol, where that came down on the side of the photograph that it wasn't transformative, in which case tattoos may not be transformative enough. So it's going to be interesting to see. At least the prosecutor is a professional. Sorry, New Mexico justice system is an entire embarrassment. I live here. I've been critical of this prosecution team. They've made a lot of missteps in this case, but this is the second special prosecutor this is not the elected prosecutor. This is a lot. Valentine's Day is my birthday, celebrating by watching court. Leonard Soph. I mean, it's a good day. Valentine's Day is my husband's grandmother's birthday, but it was also their wedding anniversary. And it was also like the day they got engaged and everything else. And I would always tease his grandpa. I'm like, so you really decided that you were just going to do one day? It's her birthday. It's your wedding anniversary. It's all of this. Like, what? It's everything. And when my youngest G is a February baby, when the doctor was looking at me and going, we're going to have to do a C-section. We'd like it to not be an emergency. Do you want to do this day or this day? I was like, not Valentine's Day. I would like it to be not Valentine's Day for his birthday. So not Valentine's Day it is. The snark from the prosecution, I'm here for it. The prosecution was definitely feeling snappy. Natalie V said, I love watching ADB react to court feeds. I love reacting to court feeds. I love chatting through court with y'all. It makes me happy. Did T borrow your rules of evidence for his assignment? He might have. I'll have to go look. Favorite place to be? Thank you, Lee. The prosecution needs to hire RuPaul and wish them good luck and remind them not to F it up for the future. Okay. Thank you, Mods, for your sterling ethical work. You're appreciated. Love the sass, class, and humor. Thank you, Bernie. That's very kind. Your rules of evidence were left with Elaine. Obviously not, because Elaine still cannot find them. Is there any way to attach money from a Tik Tok account? Yes, there is, but the TikToker, Beth, got yeeted off of TikTok. Justin says people like a Tuesday covering this, so it's not fully gone, but the main media is dropping it. Yeah, it's like me, a Tuesday, Marquee, and iNabber sometimes. Like, it's YouTubers that are still talking about it, and that's about it. Is it bad that I'm sad that there's no reference to Salem seems on point? Previous motions alluded to it a little bit, I think, but there was a lot of religious persecution arguments in previous motions. Thank you for getting ING through a rough day at the doctor. Kim, you are welcome. D said, I'm a psychic and use tarot. I will never state my readings are factual or accurate. Never. I am seeing when a spirit is wanting to show me. This isn't always reliable. I'm seeing what a spirit is wanting to show me. This isn't always reliable. Yeah, it's really strange to see somebody just tripling down on, no, this is how it exactly happened. But again, she was using that for the social media, and people get content brained, where it's like content above all else, and forget that there's real consequences behind it. And that's a problem, like a huge problem. Thank you for the gifted memberships. Drinking Coke in the hospital. Tiffany, be better, be well, be healthy. We're thinking of you. Hopefully it is a brief stint and everything is all good. Mike said last night was so much fun. Thank you, Emily. You're welcome. I had fun members. It was great. Bosnia and tequila. Jen, cheers. Boise, Idaho, drinking water. Also cheers. Thank you. Finally got my ADHD diagnosis. You opened my eyes. Jess, congratulations. We're going to go through a few more of these chats. Let's see. Question, can they get the IRS refund for payment? Attaching funds due to a judgment is a whole specific area of law, and it really, really, really depends. So it just depends. I've got vanilla coffee from Van Isle, Canada. Cheers, stay warm. Witchy Coffee Queen Jessie said it's my birthday. Happy birthday. It's my Pawnard's 5th birthday today. Happy birthday, Remy. Happy birthday. Does Remy also cook? Because that would be brilliant. How's the kiddo doing? What time is Gavel on Monday? I need to watch this. Kiddo is sick, which is a bummer. I'm going to go see how he's doing, which tends to go like, but you can't hug me though. Because I don't have time to get sick. So I will go see him in just a minute. And Dr. B is just hanging with him. He's like, I just don't feel good. I'm like, I know, buddy. What time is Gavel on Monday? I believe 9:30 Eastern time. I will put it up in the app. I will put it on all of our member spaces. Things can shift. So we will see. But I believe 9:30 Eastern time is what we're looking at, which will be 8:30 a.m. Eastern. Were keys given to a drunk person 6 months ago, or the lawsuit was 6 months ago? Neither, Northwest. The disclosure of conversations between the defendant and her attorney were given to a witness and discovered by the defense over 6 months ago. That all happened much longer ago. Janway, I am not covering this case. There are certain cases I do not cover. This is a hard pass for me. I'm not surprised. It is if you are not prepared to be in court for highly emotional cases, it is very, very hard. Can the TikToker be forced to take a loan to pay restitution? No, they cannot. They cannot. Why do her past crimes not count, but they brought past crimes in the Murdaugh trial? Hillary, this was a civil lawsuit. I don't know if there are past crimes. Not all of that has been noticed. And they do count. There are just rules of evidence that have to be followed, but I don't know if there are past crimes and if she's been charged with crimes. So it was a civil lawsuit. And during the course of the civil lawsuit, it came out that there had been, or alleged to have been, lies to police. I found Erlin's and ADHD. Congratulations, Christina. Erlin glasses are great. Can you say happy birthday to my mom, Leela? Leela, happy birthday to Lola, Lola's mom. I love the Lola and Leela of it all. Happy birthday to all the Lawnards and Pawnards. Lots of birthdays in the chat today. 555. I have some rules of evidence in my bag. How many you want? Thank you. Okay, that's funny. Let's see. Thanks for the extra ride tomorrow. That's why today's ride is a little short. Anne says, I'll be preparing for a big family event. Mother-in-law's 50th wedding anniversary party is next Saturday. Your great cooking company. Let's ride. Well, Anne, I am here while you do all the things because you are very productive, Anne, while we're on live streams. Susan, thank you for the gift of memberships. Kyla, motion to put Lawner Dictionary in the app. I'm working on stuff with the Lawner Dictionary. Don't you worry. Thank you, Bridget, for the gift of memberships. And thank you all for the members chat. We're going to live in South Carolina next week. I needed this today. Thanks, EDB. You're welcome. Sometimes we need to balance the light episodes. Got diagnosed with MG yesterday. Needed this today. Vaughn Dodds, I hope that a diagnosis will give you information, even though diagnoses can be hard to take on. The fact that she didn't see this coming makes this so amazing. Angela, when I was on it was a court call for oral argument. And at one point, the judge asked the TikToker a direct question, and the TikToker literally said, I didn't see that coming. And I was like, that is so on the nose. It is so on the nose. It was so good. It was so good. Elise, glad to be here. What an amazing week of extra EDB. Lots of me this week. All of me. Lots of me. There's going to be lots of me. For all our Phineas and Ferb fans, lots of me. Business professional for work, riding side saddle. Okay. Don't do that woo-doo that you don't do so well. I mean, yep. Catching up after work, gavel has changed. Lynn, congratulations. I want them to make more gavel changey options. For sure. I'm carrying the wheel. Love the Blue album. Thank you so much, RK. Public holiday slept in, replay crew later. I mean, I moved the stream back and I totally slept in. Totally slept in today. Let's see. That cup is gorgeous. Thank you. This is one of my favorites. Like the diamond cut it's just so good. Let's see. Migalina, thank you. Tell Chris yes, and I will do that next. So let's see. Chat, we're gonna do like 2 more questions and then I'm gonna scoot and go check on the Griffin. So according to Baker's Law Dictionary, contempt, a judge's remedy for fuckery. The Lawner Dictionary will be fun. Rebellious said I was diagnosed with ADHD this week. I wouldn't have even thought to ask my psychiatrist about it if it hadn't been for Emily's transparency about her mental health. Rebellious Arts, I'm so excited for you and for everyone in the chat who have found answers based on our discussions, because sometimes the answers aren't always what we want, but we need to have open conversations so that we can find answers. And I've told you, I talked about a story with a DA friend who ended up with blue smoothie all over their shirt. But when I was sick all the time, that friend looked at me and was like, hey, this is what I was going through before I was diagnosed with food allergies. Have you looked into food allergies? Because maybe that's like a component of this. It might be worth tracking down. And that's when I found a substantial number of food allergies that were making it harder for me to heal. And that one conversation, I was like, oh, my conversation with Octo, who was probably like at the gym or something, but my conversation with Octo when he literally said, oh no, that's how my time blindness feels too. I was like, I have been to a lot of medical professionals. I have dealt with ADHD since I was a teen. No one had ever said those words to me, but it gave me the right words to start looking for more information to understand myself better. I'm not going to change the way my brain functions. That's not realistic for me. Sometimes I can medicate how my brain functions, but it's not going to fundamentally change. I feel that the only thing I can do is to understand myself the best I can and work within that and ask for help where I need help, and then explain to those around me, I promise it's not that I don't love you. When I don't respond to text messages, it's because I either thought I responded into my head, or I wanted to give it more thought and then I forgot, or you just needed to nudge me because it came in at a point where I couldn't actually respond and then ADHD'd away. So it's not you. I do love you. Please just nudge me. And there's times when I'm like, oh, it would be great to see this friend. I haven't seen you in a few weeks. And it's like, oh, 6 months. It's been 6 months. So sorry. So sorry. I didn't realize. And then there's times where I'm exhausted and hyper fixated and like hiding in a cave. And I just need to tell people, I'm sorry, I'm overstimulated and I need to be in a cave. It's not you, it's me. And if I can tell people around me, then maybe they don't take it on as like something they've done, because I don't want people to take things on. And we all tend to look into ourselves like, what did I do to make this person mad at me? Versus that person might just be in a cave right now because that's literally all they can do to cope. So I feel like having the conversation just makes it easier for all of us to continue to have the conversation. And if I can tell the people around me, hey, this is what I'm dealing with, it really truly is just me. I'm in my own little world. And I'm not trying to impact you. I feel like it helps. And then I have intrusive song thoughts, and sometimes I just can't help it. And I tend to stream by myself because I talk a lot and I don't want to get yelled at for interrupting people. And it tends to be why a lot of the people in my life are also ADHD, because I've never had an ADHD friend get offended when they're interrupted. It's normally like an overlapping stair step of conversation and they all get it. And then when my ADHD friends say, stop, I need you to circle back and like close that loop for me so we can move on. I'm like, oh yes, it's my fault. Let's go. And it just, there's some ease in that. So, I love it. I listened to the reasons I thought I had ADHD to my psych, and her response was, do you always talk this fast? Zoe, I listed all the reasons I thought I had ADHD to my psych, and her response was, do you always talk this fast? Yes, because I might forget what I'm saying in the middle of saying it. Damn it. So hard. Collaborative communication styles fill me with joy. The way we can bounce off each other is exciting. It is, but some people get offended. And there's times Dr. B is much more methodical than I am and sometimes slow to respond. And I'm like, so we're done with the conversation? He's like, no, I was just thinking of how to respond. I'm like, I'm going to need you to speed it up. And he's like, I'm going to need you to slow it down. And so we learn to be patient with each other. Let's see. Close the loop, always part of ADHD combos. Yes. Does EDB air serve all dressed chips only with champagne? Time blindness discovered because of EDB explains so much of my history. Beth, same. And thank Octo. I could start 100 projects and never finish any. Me, until I was diagnosed and started medication. I'm able to get things completed. Here's the thing I find with starting projects, Shannon. The dopamine is so strong at the beginning, and then it goes, wah, wah, wah. So medication helps regulate that dopamine effect, and then you don't run out of the excitement about the thing. It's sometimes why it can get difficult continuing projects. So one last thing. Peggy said, Peter, lawyer, tried to put your clip at higher speeds and then put it back to normal as you speak really fast. I do speak really fast. Putting me on 2x is a feat. All right. With all of that, law nerds, I will see you tomorrow. I appreciate you. I've got things I've got to go scoot. And let's go, law nerds. I adore you. I'll see you in court tomorrow. Cheers. And let's ride. Download the app. That's what I forgot to say. Download the Law Nerd app. We'll keep you in the loop. I'm going to go see what the weather's doing. And have a good rest of your day. I'll see you in court in Idaho tomorrow afternoon. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.